issue, you're correct. They also talk about exaggerating some aspect of the evidence. The defense, the state, I should say, is totally correct that the incident on 75th Street that happened more recently, what was the name of it? Flint. I admitted that because I said, no, that those rules don't apply because this is actually an image. These are images of the event occurring as opposed to a statement of the accused or a statement of a witness, which were the case in the Franklin and Anderson cases. And so I do feel that those rules are not, the rules to be derived from Anderson are not strictly applicable to the to footage from the actual event which is claimed to have been criminal. So it's not just that one case, there have been other cases that I've admitted these videos and let the jury play them. I complain about the case of, well, I don't remember the man's name, but he was convicted of attempted murder of a police officer. Well, actually, I think of reckless endangerment or something, but because of video footage that they had to come down here and watch on a tiny computer, and we had to bring them down 3 at a time because we could only let them see it one time. I think that's so outrageous. But, you know, I have to be aware. You want me to kind of just let them have what I gather what you say, although actually most of the time your office has come in here and told me, no, Judge, don't risk our case. So don't send this. What do you want me to do? What do you want me to do? Tell me.
Judge, I do not believe Anderson applies directly. I believe that because it is of all these requests are of the incidents themselves, that I believe the jury should be able to watch them as they see fit, watch them, pausing them, rewatching them, watching them in any way they see fit, in any configuration they see fit. I believe that the Franklin and Anderson cases, I understand how someone's statement, a videotaped statement, could be overemphasized. I do not see how videotapes of an incident could be overemphasized or looked at too much. And really that's what this whole trial has been. While there's been lots of testimony, almost everything testified to is on video. So to me, I believe it is clear that given that it's a videotape of the incident, they should be able to view it as they see fit. Now, Anderson, again, of a statement, says it should be in open court. That certainly can be done. The jury may feel uncomfortable, obviously. So I think if the court makes specific findings as to why it's appropriate in this case to send it back, we could send it, or actually what I would propose is making the courtroom the jury room, clearing out the courtroom, checking for any devices that would be recording the deliberations. We can either give them all the exhibits and instruct them to only watch the numbers that we agree on or that are allowed, or we can put them on a separate drive, the exhibits that they've requested or that they'll be allowed to see, and they can essentially have access to all the screens here and they can play it and do it as they see fit. Now, with this distinction of it being the incident itself, if the court makes findings of why it's appropriate, the state believes that it will survive any scrutiny on that issue if there is any kind of guilty verdict.
Well, you're suggesting an abandonment of the insulting precedent of the last hundreds of years that the jury might overemphasize some aspect of the exhibit. He says it should be played only once if it's played at all. And you say play it as much as you want, which my intellect tells me is the best way, because as I talked about the Tsarnaev case, that's how it got solved. And it seems to me this is a pursuit of truth, and you should take the course that you think will lead you there. And if the jury thinks they want to look at it 80 times and they want to talk about it and criticize each other for their for their respective views of it, I think they should be allowed to do so without interference on our part. That has not been the law in this country, which, in my estimation, treats jurors very poorly. So I don't know, your office, this is the first for me that your office is agreeable to this. But that doesn't mean you can't do it, because you can.
And usually, the only time I've ever encountered this issue, I can't speak to everyone that's been in my office the last few years. The only time I've ever encountered this issue with you or any judge, I believe, is because it's a statement. And the video of the incident is different. So, and what the court must weigh is whether the exhibit will aid the jury in proper consideration of the case, which you and I at least agree. Whether a party will be unduly prejudiced by submission of the exhibit, they've already been submitted, and then improper use. I understand how, especially a statement of a child or a statement of a defendant being reviewed over and over and stopped and rewound, how that can be an issue. But if it of an actual incident like this, which is what this whole trial has been, is showing videos of the incident, and I think it is fair to this jury and fair to the process, and frankly fair to the defendant if they're able to see the videos as they see fit. So we can either give them, if the court adopts this, we can give them a drive with the acceptable exhibits. They can play them. They could have access to the court technology if everyone is kicked out, and it can continue as that. I don't know if the court can allow that with its calendar, but
this is more important than anything I've got on the calendar.
The state's position is that Anderson is very strictly relevant only to a statement of a witness or defendant.
By the way, what about, I now have had the chance during the break to read the defendant's motion for dismissal.
Yes.
And there are allegations made there about the material that was provided to them.
Yes.
Certainly if I follow through on what you want, I think I warned the other day because I was queasy, very queasy about this particular exhibit from the drone. And we exchanged a lot of emails over the weekend about it. And I think I warned you the other day that you're putting an awful lot of emphasis on this. And if it turns out that it's not technologically sound, I referred to it as the situation as a house of cards. This is just more weight on that. If I now allow them to review it without restriction as to the number of times,
Judge,
you're comfortable with that?
we are. Now, if I can respond at least to that portion of the motion to dismiss, it's factually inaccurate. So let me go back to the first Friday of trial. Mr. Lukowski was testifying. In the middle of his testimony, I got a notification that there was someone at our office who was refusing to give his name with a drone video. This drone video was shown on Fox News a couple days after the incident. It apparently was on the internet briefly and then taken down. The defendant's first attorney, Mr. Pierce, appeared on the Tucker Carlson show and discussed the video and seemingly brought the video. We've been told since then by the person who took the footage that they've sold the video to Fox News. Now, we've had a poor quality of this video the entire time. It's actually in Exhibit 41, which the defense submitted. On Friday, the individual who took the footage, who had been unable to find, came and airdropped the footage to Detective Howard. Airdropping is a way that it just goes from phone to phone. It doesn't go through text messages or email. It has to be iPhone to iPhone. So in the middle of Mr. Lukowski's testimony, I asked Mr. Howard to go, and our investigator, to go speak with this individual and see what he had. I suspected it was this video from the Tucker Carlson show. It was. Detective Howard got a airdropped copy. He brought it into court. As soon as the next break happened, which I believe was just minutes after he arrived, as soon as the next break occurred, which I believe was just minutes after Detective Howard arrived, I took all 3 defense attorneys in the back to discuss a couple of issues which are not relevant, and I also indicated that we now had a much better quality drone video. Detective Howard asked them how they would like to receive it. Ms. Wisco asked that it be emailed to her. He emailed her the file. Now, somewhere along the lines, whether it was, it appears the issue is, I believe Ms. Wisco could not have an airdrop because she has an Android phone. Going from an iPhone to a Android, it appears somehow compressed the file.
Was she made aware of that? Because I have an Android phone too.
We did not know that this would occur. If I knew how to compress files and knew all this technology things, I'd have a much better job. So this file was given to us. We gave what we fully believed was the full file to Ms. Wisco. It was admitted to evidence. It was the authenticity was stipulated to. It came in without objection. We've heard many times this trial how there was no objection. It was an exhibit for 4 days and played and shown to the jury and on the screen for 4 days. And then on Friday is when I think we all discovered that something had happened to Ms. Wisco's file. She played it on the big screen. It clearly looked different than the copy we all had. I believe we offered to airdrop it to the other attorneys, and I think it was declined because they didn't know how to use airdrop. And then we got her the full copy. We cannot be held responsible for the software on Ms. Wisco's phone. We didn't compress anything. We didn't change anything. That would have been something that happened in the transfer that we had no knowledge of. We of course did not mean to give them a different copy, and until Friday when Ms. Wisco played it and it looked different than what we've been looking at, we had no idea it was any different. And then when requested, I gave her, so what I did is I took an email from Detective Howard. He emailed me the file. It was not compressed. I don't know, probably because it's Apple to Apple, or I was using Gmail at the time. It was the full, as far as we know, the only copy of the video we were ever given, the only copy that's ever been had, and then I put it on a thumb drive to give to the State Crime Lab. So I cannot explain why Ms. Wisco's file had been compressed. That is not something that we can be held accountable for. We didn't know it. We don't, and if Ms. Wisco knew it, it wasn't brought up until Friday. Now, there was some dispute Friday about there being different copies. There was no different copy. The software on Ms. Wisco's phone, or whatever software she used to view it, compressed the file. The only compressed file is the one Ms. Wisco has. All the ones that we have seen, and we did not alter the file. None of us know how to alter the file. None of us know how to compress the file. We wouldn't have had time to do so. You can probably go back on the footage and see when Mr. Howard, Detective Howard brings it in, and while Mr. Lukowski's being questioned, we're looking at it to see if it's the drone footage that apparently the defendant's first attorney had or was aware of. And I understand he's different attorneys now, but this is still the defendant's attorney at the time knew of this 3 days after the incident and was talking about it on national television. So to somehow now accuse us of compressing a file and somehow being able to do this technical wizardry to somehow sabotage the defense is preposterous. The defense saw this video and thought highly enough of it that they went and bought a large television that is now being used in court because they wanted to show it. And now all of a sudden to come back and say, well, we had a bad copy, they could have checked, they could have asked for a thumb drive, they could have asked for whatever. As far as we knew until we had this hearing on Friday, everyone had the exact same copy. And that Ms. Wisco's phone compressed it is not our problem. It's not, we're not responsible for that.